As landmen, we take a lot of things for granted as far as steps you take when you're securing an agreement or an option, de-risking an asset or a property. We take those things for granted.
There's a lot of effort going on while these title commitments are being issued. A lot of money and good time with great minds spent to plan. If we can get in front of that and know that, hey, this is going to be good for minerals or this is going to be an absolute nightmare for you, if it's an absolute nightmare, you've just saved tons of people in your company time and energy.
And money.
Welcome to the Land Department Podcast. The state of land and energy as we see it.
Brent, we've been trying to do this for a while. We're finally getting around to it.
We're outside of conference season, so we were able to tie Natalie down.
We were.
Yeah. So
Welcome to the podcast, Natalie.
I wanted to introduce Natalie Johns here to the podcast world. Most folks know Natalie. She's worked for us for a good little bit now and worked her way through from kind of contractor to project manager to now she's director of our renewables department. So what's the official title? Director of Alternative Energy?
Alternative energy. You kept it fancy, Brent.
I did. It was original. I can't even say that 3 times backwards. But the long and short of it is she's in charge. She is kind of steers a direction for our renewables efforts across all the renewables, all the little renewable pie. She's really embraced it. We're just super happy to have her as part of the company, and she's kind of really devoted herself to understanding and learning the business cases for various renewables projects, how to take the work that we do as landmen and translate it to the needs of the renewable space. So she's been on tour. Everybody knows her in the renewables world, but we're very excited to have her on the podcast today. And we're just going to kind of pick apart some subject matter around title. So Natalie, welcome.
It'll be fun. Thanks for joining us.
Thanks.
Yeah.
Happy to be here.
So we're going to talk about de-risking. This is the really hot topic and really going to speak to a lot of developers, but I want to hear from you. What's interesting to you right now, Natalie? What's happening in your world on the day-to-day?
We're starting to see a lot of mergers and acquisitions in the renewable space. As from the inception of the Inflation Reduction Act a couple of years ago, we've had new renewable startup companies come in and acquire projects, acquire land, get these projects ready for NTP. And a lot of them are selling the projects off now to folks that are actually going to operate them. So we're seeing a lot of those transactions happen. We're getting to help do some of the due diligence on those projects and make sure that, the buyer is really getting what they say they're getting from the seller. We're getting involved sometimes with the sellers, getting things ready to package up for the buyers. So outside of all of our day-to-day stuff with acquisitions and title policies, we're having a lot of fun in the M&A space too.
Yeah, it's the natural progression of things, right? We've seen it in oil and gas. We've seen it in, some of the early renewables efforts. When you have this influx of activity and I guess essentially supply of deal, there's the consolidation. People are getting acreage position. They're getting those primo positions and they've got them locked up and they've taken it 70% of the way there. And then they're wanting to package it up real nice and pretty for someone to buy. And we see it in oil and gas. We see it in all these spaces. So it's a familiar thing to us. We've talked a lot about it internally over the last year and a half, and we're starting to really see that come into play. So, some of the things we want to talk about today is, things you need to be thinking of leading up to your due diligence or your transaction, and some actions you can take from a buyer standpoint when it comes to potentially securing either your individual site or a group of sites from another operator or someone who's putting a package together to sell.
Yeah.
All about title today.
Yeah, you're spot on, Brent. And a lot of this is, even to get to that M&A point where you're ready to sell an asset, you have to, or you're ready to operate it yourself. It has to be fully de-risked. And a lot of what we're needing to do in that space is have proper mineral title run for them. Make sure that they're addressing all of the mineral owners in oil and gas producing states where they have these energy projects so they can secure the proper surface waivers, get fully insurable, So that's another major component of what we're seeing as the large amount of activity right now in the renewable space.
It's very much mineral title oriented right now. But maybe just to kind of step this back to Title 101, because, as landmen, we're both career landmen, Natalie and I, we take a lot of things for granted, as far as steps you take when you're securing an agreement or an option, and the steps you take progressively with de-risking an asset or a property throughout its kind of life cycle up to and through your permitting process and ultimately construction. We take those things for granted. So maybe, Natalie, can you just step back and just bullet point, hey, during these basic steps of your acquisition effort and up to, say, through your title commitment, let's just bullet point where you need to have title done, what kind of work you need to maybe do in support of your acquisition efforts, and then when these other kind of steps of title come into play.
Sure. So, ideally when we move into a new prospect and say we're acquiring the asset for a company, ideally we like to go out and lease check before we start acquiring assets to see who else is out there in the area. And then when we're acquiring the assets, as we're doing the contracts, work smarter, not harder. Sorry. So we like to do a quick cursory run to verify surface ownership for these surface agreements that we're doing. We may run it back, 20 to 50 years, depending on what the client approves and is wanting. But I make, arguments for both sides and then let them choose what's best for them and their budgets. So we'll do that just to verify the contract. So we don't have to, it's always hard to have to go out and get somebody that you got to sign the first time, sign 2, 3, 4 more times because of errors. You don't want to do that.
And that's let's kind of dive into that. Like we see it often, a company will go out, they're working off of tax rolls, for instance, or working off of a software that gives them a surface owner's name. And they're working largely off of just what the landowner has told them. Oh yeah, I own this. This is mine. This is me and my wife's, or whatever the case may be. And we see agreements drafted based off of, information from the tax rolls and word of mouth from the landowner. And what we also see in some of those instances is, as you move down the line, well, Brent Broussard doesn't own it. It's in the Broussard family trust, or it's Brent Broussard and his brother own it in undivided interest. And again, we talk all the time about opportunity loss. Well, you've spent all this time thinking you've got a good deal, when come to find out, now you got to go back to them. And every time you go back to someone, the wallet has to come out. It's just the nature of things. It will cost you. So, what we're looking for in that initial title run from on the acquisition phase is a good source deed, a good deed that properly describes the tract of land that you're securing. And then we're ensuring that the caption of the agreement, which means the grantor, is properly and correctly entered and included in that agreement, such that when you sign that agreement, you've got a marketable contract in your hands. You've got it signed by the right person. You've got the proper description of the lands included. And beyond that, you're going to start to pick up an idea of any surface tenants, any more recent activity that affects the surface that may be relevant to your transaction or your project that may not be visible yet on the ground. It's going to help you identify pre-existing rights. So that's the importance of doing like that step one abbreviated cursory review. So Natalie, once you've done that, take it to the next step.
So once we've done that, we know that this person owns the surface, then we're able to go ahead, get the contract done. And then my next suggestion to the client is, hey, let's go ahead and start looking at the minerals ownership. Don't kick this can down the curb. They don't all listen to me. But I try really hard to protect them as much as I can. It's important to go ahead and look at that early on, because a lot of times what I see and what the trend has been is for them to go and secure their title commitment policy, and then they get the policy, the preliminary policy worked out. They have surface title run, and then all of a sudden it's this panic rush to go and get secure surface waivers. And I've had clients come to me with their title commitment and say, hey, I have this commitment and it references a couple of different mineral reservations in here. Can you go get surface waivers from these people? They're the mineral owners. And I'm like, whoa, whoa, whoa. Those deeds are 40, 50, 60 years old. You don't know who the mineral owners are. We need to go run that title and then decide based off that title who the actual mineral owners are to get the surface waivers. Yeah. And that gets really hard because a lot of times by the time it gets to us for that, if they use that model and we don't do it on the front end, then we're up against their option agreement deadlines. They may be towards the end of their deadline to execute, and it may leave us 3 months to go run title and secure all these surface waivers. We don't know how many there's going to be underneath there, right? Yeah. Yeah. So it's doing it earlier on in the process, and ideally doing it at the same time that you're getting your surface title commitment is the way to go, because you can look holistically at the whole picture at that point and really decide, you may have a great surface area, but you may have 150 mineral owners.
You may have garbage minerals below it. I think, right. Natalie, let's step back. I'm trying to, again, always try to remember and think that we're trying to just talk to someone who's brand new to this space. So
sure. Let's
explain typically in a title commitment what you see with respect to minerals in a title commitment. You hear it referred to as exceptions. What if you're a brand new, or someone new to the renewables business and you're a developer, you're working in the real estate group or whatever the case may be, and you get a title commitment put on your desk. Typically, what do you see a title commitment? How does it address the minerals?
So it's when they're running the surface chain of title, if the examiner does this, they're supposed to, but again, we're humans, right? So if the examiner sees a mineral reservation in the chain of title, they're going to note that in their run sheet, and then it's going to show up as an exception on the title commitment. That means that they are notating that there's been an exception somewhere in the chain of title for minerals. That does not mean that mineral exception has been run fully out to present. Yeah. So just because you see the exception on your Schedule B or whatever it may be, okay, that does not mean that is the current mineral owner. That deed that they're seeing could have been from 50, 80 years ago. And those minerals could have moved, 100, Those minerals could have moved through many different hands. Yeah. So,
and I think further to clarify what you see there, that's just an exception saying that this commitment does not cover the minerals, and it's subject to these reservations that we've observed, although they do not certify that those are the only reservations in the chain of title that affect the surface. It's important to understand the work that's done in a title commitment on the surface side. It's very much they're pulling an abstract from title cards, and title companies historically, their only concern has been surface transactions from person A to B to C to D all the way through as it pertains to the breakup of the surface. Oftentimes, if you have mineral conveyances from, a mother to a child, say, I'll give you all my minerals, whatever, that's not tied to a geographic location at times. You see all these things. So that title commitment is essentially accepting and excluding the mineral breakdown, the mineral examination from that commitment. That's where the work that a landman kind of comes in. That's where the mineral, that's the important part about it. Natalie hit the nail on the head about a title bomb. You can have a great surface project. It can check all the boxes as far as connectivity, development possibilities, favorable contracts, whatever. But that mineral ownership can break up and be very complex. You could deal with working interest owners, E&P companies. This happens all over the country on these projects. So those are things that are important. That's really important to understand what's included in your title commitment. And part of that process is that we see it's companies realize that this commitment does not include the minerals, and they only know to do the minerals because the title underwriter at some point after they've had this thing on their desk for 6 months tells them, oh, you've got a mineral exception, you need to do mineral title. And again, we always hit on opportunity loss and de-risking. What opportunities have you lost not knowing about what's exposed to you in the mineral side of things? So that's what we're working to resolve. So let's get back into it, Natalie. So you've got a title commitment. It's you have a mineral exception, and then what?
So, at that juncture, the good and right thing to do, like what I would like for my clients to do is the minute that they get their title commitment in, if they haven't already authorized us to run the mineral title, then I would like for them to stop and let's look at that title commitment together, and let's get in front of that and address those things, address those minerals head on. Because what happens otherwise is there's a lot of people involved in these projects. You've got all your electrical engineers, you've got your project developers, you've got your site people who are planning site construction. There's a lot of effort going on while these title commitments are being issued. A lot of money and good time with great minds spent to plan. And if we can get in front of that and know that, hey, this is going to be good for minerals, or this is going to be an absolute nightmare for you. If it's an absolute nightmare, you've just saved tons of people in your company's time and energy, right?
And money.
By being able to look, yes, time is money. And that's really what we're trying to do. I've seen companies waste a lot of time on stuff that, and a lot of people's efforts on things that aren't going to work out because of the situation that they have with the minerals and the complicated surface waivers underneath.
Yeah. So we can dive into that a little bit. And again, just talking about basic things that happen. It's very common for the mineral tracks to have a different configuration than the surface tracks that you've secured your option or your solar agreement or battery storage or wind agreement on. And so talking about some of the things you can expect and how you can maybe navigate challenges on the mineral title. So say you've gone through your acquisition, you're under an option agreement, you've ordered your title commitment, and say you followed Natalie's advice and are very proactive about getting a mineral clearance, a mineral ownership report done. Some things that report, that request to your landman should be very specific in the sense of you should let them know the outer confines of your area that you want them to examine. You should make sure that not only are they giving you an ownership report, but they're giving you access to all the documents in that chain of title. And that comes into play when you get on down the road to underwriting. But those are some basic things. You need ownership report of the minerals. That's on a mineral tract basis. We see it a lot of times that people will tell their land broker to only run the minerals as to the surface confines of this parcel. And you try to get mineral ownership reports that just fit the surface parcel. We encourage to turn in reports that are on a mineral tract basis. And the importance of that is you need to understand, say if you've got a 1,000-acre option area, you may have 6 mineral tracts that underlie that 1,000-acre parcel, and they may be in different configurations. One mineral tract may be much less complex and busted up than one of the other parcels. So what you end up with is you have ownership reports that cover all the specific mineral tract outlines, some of which may be provide a path of least resistance to getting waivers than others. So when you get that ownership report in, you want to have a map. You want to have everything that you can overlay with your surface agreements and help you maybe make decisions on where you want to pursue options. It's very common in the work that we do that we turn in mineral ownership reports and then sit down with the client and say, okay, hey, you've got 40 mineral owners and a HBP oil and gas lease or held by production oil and gas lease on the east half of this project, but on the west half, you've got 500 acres of clean. It's by 2 mineral owners. It's not under an oil and gas lease. We have a very high probability of being able to secure the waivers of the surface use on this west half of this project, and we can get that done very quickly, and you have an actual insurable project as it pertains to this west half of the effort. And that's kind of where it all really comes together. The mineral title is really all about de-risking and insurability. You can't construct your project unless you're insurable. We've had other podcasts where we've introduced Dudley Select Title and the work that we do there and why we formed that company to kind of bring this process together, bring the mineral review and the surface underwriting, the title insurance part of it together. Because you really have to look at that mineral review holistically, right? How it fits into the constructability of your project. So kind of went down a little bit of a wormhole there, but it's just a complicated thing. You need to understand that your minerals, how they lay out and how they fall into place are going to shape maybe the path that ultimately you construct. So then you're factoring in minerals, you're factoring in environmental stuff. It's a complicated process, but it's really about information. The sooner you know that information, that's why Natalie emphasizes to do that mineral title work early on as possible, because it just gives you more information to ultimately try to drill down to what's constructible.
It's about making good business decisions. And you can't make good business decisions unless you understand the entire picture. And so that's what we really want to do is let's eliminate when we're looking at something holistically, you might be looking at the wetlands and floodplains, you're looking at capacity, you're looking at, where you're going to tie into the various substations or lines, but you also need to look at your ownership. You have to look at your ownership. Brent mentioned earlier, there could be some of these, especially depending on, and it is different all across the country, and I'll get to that in a minute, but specifically in some of the oil and gas producing states, we know that some of these folks are oil and gas producers are harder to get shared use agreements out of than others. So if our clients will look more to us as a guide, helping them along the process and making sure that we're helping protect them from all of some of these different scenarios, then we can quickly tell them, hey, look, we haven't been able to ever secure a surface use agreement out of these people, or, hey, these people over here really will work great with renewable energy companies. And we can sort of push them in the right direction so that they can get to where they need to be quicker and not waste time and money. I mean, that's the whole crux of it, Khalil, is just let us help you not waste time and money.
Yeah. Well, I'd love to hear an example of this, like from soup to nut, like the whole integrated process. Can you share an example of, a client that you've worked with to go through this entire process the right way, and then the risk that you're avoiding by going through that process?
Sure. I can't share their name. They'll know who they are.
Obviously.
But we have a great client that engaged us early on in their process for battery energy storage. And they worked hand in hand with us and really trusted us to help make decisions with them. We were able to help them acquire their assets across the country. And after they acquired the assets, when they ordered their title commitment policies, they also ordered their mineral title at the same time. And we knocked all of that out. They were able to make quick decisions based on what they were seeing, and they were able to redirect where they needed to. So these folks are moving at warp lightning speed, and they're doing it successfully. And they're because they're using basic simple land practices, and they're working with us on it.
Yeah, they've adopted that into their process. So
100%.
They do their mineral work. They order their title commitment. They look at the title commitment of the surface and the exposure on the mineral estate. They then by that process, they're able to quickly eliminate things that are going to take time and put that on the back burner, and then really focus their efforts on, okay, what's the path of least resistance? What is more probable to get, the waiver secured so that I can get to underwriting? And then they focus their efforts on that. It's an efficient turnaround. They can reduce the timeline on these projects sometimes by years, because you're not having to deal with an operator that's not incentivized to help you, or to cooperate with you, or a mineral estate that wants, $1,000 an acre to waive their surface rights. And then you're like, you're at a point where you just have to continue to put good money at a bad cause, to try to get to the path, to the end. So Natalie touched on it. You order your mineral title. When you do your title commitment, that comes in. The next step is, obviously, you've got the waiver work that we've hit on a lot, but there's other curative. In oil and gas, it's referred to as curative, right? We get a title opinion from attorney, and it's going to outline defects in that title. There's always something. Somebody's name was spelled one way in one document and another way in another, or there's a surface tenant out there that they've got a grazing lease, affecting the property. You've got to go negate that. You've got to negotiate that out. You've got to address those things. Maybe a use and possession, like where there's maybe some uncertainty as to a boundary line, or an inconsistent legal descriptions from conveyance to get conveyance. Those are all things that don't get a lot of attention, but are absolutely essential. They're part of that process. Those are the things that landmen do every day. So, you can expect your land group, whoever you're working with, whether it's Dudley or any other reputable group out there, those are things you can lean on the landman to do. They're going to be able to help you with your other curative items in that commitment to, again, clean up your title, give you marketable title, and allow you to move forward with your underwriting. So your land team is going to be doing that work. For us, with an integrated title insurance group with Dudley, we're then able to work hand in hand. That's all happening under one roof. We're looking at all that curative work that's being done, on the Dudley side, the waiver work that's done on the Dudley side. And we're working directly with the underwriters to help articulate and convey that, hey, we've de-risked this project. We've secured 80% of the waivers, on this, and really be able to pitch your case and say, hey, I know you want 100% mineral title coverage on this, but we've got 85, and here's why we think that de-risks this project. You have to be able to present a lot of information and be able to have an organized and valid case for working with that underwriter to agree to say, yeah, okay, you know what? I feel confident enough to insure this project. And that's what Dudley Select Title is all about. It's about streamlining that process. It's about being the conduit between you as a developer and the underwriter as the person that's ultimately signing off on the insurability of your project. Those are all places that a landman is going to fit in. That's all places that a good insurance group is going to help and guide you and support you through. And in oil and gas producing states like Texas, like the states all through the Northeast, the Midwest has a tremendous amount of oil and gas development that people don't realize. The Rockies, all these places in New Mexico, are going to have that kind of exposure, and you better get ahead of it early. That's some of the things you need to be looking for, whether it's Dudley or any other group that you're working with. They need to be able to help you and support you along the way. And the more informed and the more institutional knowledge they can gather in working through your project, the better. If they helped with the cursory title on the surface, they're going to gain a little bit of knowledge. And if they're doing the mineral work, they're going to gain more knowledge. And if they're helping you with the curative, they're going to gain even more knowledge. So you can take advantage of that knowledge that they've gained or that your group has gained throughout that effort to just be more efficient and make more informed decisions.
Natalie, you just
Exactly
gotten
right.
back from so many conferences and you're talking to the renewables developers all the time. How many would you say are really informed on this process and the needs that they have to de-risk versus the ones that you're having to educate really on the entire aspect of the oil and gas history in these states and getting the mineral waivers?
The first thing I'm going to say about that is this. What I see in the renewable space is some incredibly smart people. They're definitely tackling an entire new area of energy with gusto. The folks that come from maybe a landman or oil and gas background, obviously those folks have a leg up because they understand the basic principles of what needs to happen to acquire and de-risk energy projects. They've already been doing it on the oil and gas side earlier in their careers. Some folks are a little bit newer to it, and it doesn't mean that they are disadvantaged in that sense. Those are the ones that I really try to focus my energy on forming relationships and educating them and helping them to get comfortable with us and helping them to understand that we do have their best interest in heart. We want to protect them. Uh, you know, to answer your question, I don't really know. It changes rapidly. Because the other thing I see in this space is people moving between jobs all the time. So I joke with
Yeah.
Brent, I feel like we need like a spider web wall on somewhere in our office so we can track where
Who's
everybody is
where?
now as they move around. Yeah, but people are starting to understand the thing that we've been doing this past year. We've been very lucky to be able to speak at a lot of REAP Plus events. We were able to speak at the SIA finance and tax seminar. Uh, we've done participated in some really great events and been able to talk about the same situation. And I think that we're starting to, from what I'm seeing, and Brent, you tell me if you see differently. I think I'm starting to see people pay attention, and we're getting so mature in this process now that what they maybe the finance folks and the engineer folks, maybe they didn't understand in the beginning. They're now starting to understand why it's important because it's now happening,
Yeah.
right? With the need for these surface waivers. So I think that we'll as this space matures and as people who historically have never had to deal with land or uh, surface title or mineral, or maybe they've only dealt with surface title in a commercial aspect, but now they're having to look at it in a different way. I think as time continues on, they're going to become more knowledgeable, and these things that we're continuing to shout from the rooftops will just become commonplace part of their development plan. And that's my hope.
Yeah. And we talk about cautionary tales. It's an evolving space, right? To Natalie's point, a lot of really smart people are working in this. They're building businesses from the ground up. We have to keep that in mind. They're starting from nothing a year and a half ago to, trying to form a business that's operating in 15 states, potentially operating in 15 states. So they're going to make mistakes. They're also going to get better. They're going to learn from mistakes. A landman, a land service company is there to try to keep them out of the ditch along the way. But people are getting more efficient. They're, having some situations where it's costing them and costing them significantly because they maybe skipped over a process or didn't place a value on doing some of the things that we're talking about. That's probably a prime example is what we're starting to see. And in the due diligence work that we're doing, the transactional support that we're doing from a land side, we're having a field day, Khalil, representing buyers in this kind of title clearance side of things. Companies scramble together. They think that, hey, I'm gonna get 7 sites. I've got 7 option agreements. I'm about to flip this and make some money, which is great. That's an American dream, right? That's fantastic. I have something you want, and here it is, tied up in a bow. Well, come to find out, it's an old ugly cardboard box, with the tape torn off of it by the time we get through with it, because we're able to really quickly identify, hey, you didn't properly vet this, and your project isn't insurable. So what that ends up doing is, as a seller, you're having to give discounts. What you thought you had $10 million worth of properties. Well, you've got 6 now because 4 of them are going to require hundreds of thousands of dollars of additional work and research, and it's nowhere near where you thought it was from a constructability and insurability standpoint, or at least that you purported it to be. So we've done that on a few occasions already where, we come in, we do an assessment of, all right, what work have you done? Was it done properly? Was it done by in a reputable group in a way that allows us to be comfortable with the product you're putting in front of us? And oftentimes they don't, or they're agreements from the wrong person, or has a bad legal. The slightest things can cost you a tremendous amount of money when it comes to transacting in a B2B type agreement. So we're seeing that a ton. Natalie just this week brought up a situation where a client of ours reached out to us. I don't say in desperation, but like they had a realization that, oh crap, I thought I had something, or they engaged us to do one thing. And as we started working through it, we'll let Natalie pick up and talk about the mineral title deal that we just got to our desk. And it's kind of really why we focused on the content of a title commitment earlier.
Yeah, this one is, again, relationships with clients are important. And the clients painting the full picture for me is critical when we onboard that project so that we can get them where they need to be. This project came in, they gave us a Excel spreadsheet with ownership for minerals broken down over multiple tracks. We took, they said, we want you to go get surface waivers from these people. We engaged our MSA, got a landman out there, and what started to happen and become very apparent to us was when the landman started making calls, a lot of these folks were deceased and had been for a long time, or they were these individuals were now part of family trusts. And so we went back to the client and we said, hey, do you have the actual mineral run sheet and documents associated that supports this ownership spreadsheet you gave us? And they didn't. The ownership that they took was off of the title commitment policy exceptions on the Schedule B. So here we are at
which
the
actually wasn't
11th
ownership. It was just a listen accept.
Yeah. Yeah. So we're at the 11th hour and we're having to go run that title real quick and determine who those owners are and get those waivers, the correct people, waivers from the correct people and the current actual owners now to fully protect them. So lesson learned for me in the sense that I'm never, if you're a client or a future client, I'm not going to just accept your spreadsheet. I'm going to ask you for your title.
Yeah. And those are some things that you should do, right? And let's talk about how you can navigate around or negate that type of scenario. So if you're a broker, a landman, and you're working in support of a developer, that you want to ask those questions. Don't just assume that this spreadsheet that they hand you is the gospel. Show your receipts. How did you get this? What work was done? Ask those very specific questions. On the internal side, we see a lot of times, a lot of companies are compartmentalized where there's a group that does the acquisition work and there's another group that, works on the development. And real estate kind of sometimes falls on either side of that. You don't know, I guess maybe the best way to phrase this is if you're a receiving party internally where an asset's come from one person that maybe has got an option agreement and maybe has a title commitment done, and they hand that to you to pick up with development, you're going to want to ask those questions. What work was done? Show me the ownership reports. Make sure you have the documents. Be asking very specifically about these because you can't assume. I guess that's the word of caution. Do not assume that something was done on the mineral side. Just because you have a spreadsheet doesn't mean that it's gospel and doesn't mean that it's been properly vetted. You want to make sure that you're asking those questions and you have access to all that. It's going to help you make informed decisions. It's also going to be part of the things we're going to be asking for when we're doing due diligence. We want to see evidence of this work you've done. I just want a stack of waivers. I want to know, do you have waivers from the right people? Have you got them? Are they the proper names? All these things, it really goes back to elementary. Show your work. It's very basic things. Show your work.
And it's hard when you're navigating this because there can be different departments involved and again, it's a new space, new territory, so companies are changing their systems. But what I will tell our existing clients and future clients is if you don't know what questions to ask the other department that maybe handled this, do you use your bat signal? Get a hold of myself, Brent, Steve. Okay, we will come and we were happy to hop on a Teams meeting or hop on a phone call and gently ask those questions to that other department with you and for you. We don't expect everybody to know everything about this. That's why you hire us as consultants. And so we're here to have your back and we're here to help you navigate it as best we can and use us as that tool. And don't be afraid to ever say that you don't know, because that's what we're here to do, because we do know.
Natty J will keep you out the ditch.
We'll try.
Well, this has been, I think, really helpful for someone like me who's very green in this area, but also other renewables developers and renewables workers who don't know the process as well and aren't familiar with the things you need to be aware of if you're going to de-risk your project. So thank you both for sharing so much. Natalie, thank you for joining us today. Really great to see the work that you're doing, and you've got a tall task ahead of you. So excited to see where the alternative energy space is for Dudley in the next couple of years. I think it's going to grow significantly, especially due to your efforts. So thank you.
Oh, thank you, Khalil. Thanks for having me today.
Absolutely.
Thanks, Natalie.
Take care.
Thanks for listening to The Land Department. Check out our website in the show notes or visit dudley-land.com to learn more about us.